Welcome to Business 101 class. Today, we will look at Section 2 of Unit 6, Negligence and Duty of Care. Session objectives. By the end of this session, you should be able to explain negligence, duty of care, and identify a situation in which a party owes a duty of care to another. We will consider the definition of negligence by Eduse in the case of Hassan Kotokori v. Moro Hausa. In this case, the learned judge stated that negligence means more than heedless or careless conduct. It properly connotes complex concepts of duty, breach of that duty, and damage suffered by the person for whom the duty was owed. The definition gives us a clear indication that, look, negligence is not about just your careless conduct. It goes beyond that. Before you prove negligence or before you succeed in action for negligence, you have to prove that the defendant had a duty towards the plaintiff. The defendant has breached that duty, and for that matter, the plaintiff has suffered damage. When these elements are established, so when we're able to establish these elements, then an action for negligence will suffice. Now we will consider the old case of Donogwe versus Stevenson. Before I give you the ruling, let me give you small parts of this case. So a friend bought ginger for Mr. Donogwe. Now, after Donogwe has drank the ginger, after taking half of it, he saw a decomposed snail in the bottle. So he suffered nervous shock, or in other words, he fainted. Now, after going through medical process, or after he was healed, he brought action against the manufacturer of the product. So the court has to determine whether or not Mr. Donogwe can recover for the losses that he incurred as a result of the damage caused to him by the drink as a result of the snail. Now, the court ruled that under law of contracts, because Donogwe was not a party to the suit, he cannot bring action against the manufacturer. So it means that they were dealing on the issue of what? Privity of contract. So when you are not a party to the contract, you cannot sue. But on appeal, the House of the Lord said, no, look, it is possible that a person may be able to sue another who caused them harm or loss, even if there is no contractual relationship between them. Let me give you a scenario for you to get the picture right. Let's assume that you as A, you bought Sobolo from B. Then the Sobolo that you bought from B, you gave it to C. C drank the Sobolo and she fell sick. Now the question is whether or not C can bring action against B to recover any losses that she has incurred because of taking the Sobolo. Now, under the law of contract, C cannot bring action against B because there is no contractual obligation between C and B. However, the principle under Donogwe versus Stevenson said that it is possible that even though there is no contractual relationship between this party, because C is the final consumer of the product or the Sobolo, it is possible that C can bring action against B. That is a situation. That's exactly what happened in the Donogwe versus Stevenson case. Now, in that case, the House of Lords created a new principle that everyone has a duty towards his or her neighbor, and we explain the neighbor principle very soon. Now, the House of Lords stated that Donagwe could successfully sue the manufacturer for damages that he incurred, or the damages that he suffered. Now, the House of Lords laid down the principles or the requirement for an action for negligence. The court indicated that the plaintiff must prove the following element: that the defendant owns a duty of care to the plaintiff. The defendant had breached the duty of care, and for that matter, the plaintiff has suffered loss or damage as a direct consequence of the breach. So you had a duty of care, you failed to discharge the duty of care, that you breached the duty that you own to the person, and because of that breach, the person has suffered some loss or some damages, and these damages were as a result of your direct action. Now, when you're able to prove all these elements, then an action for negligence will suffice. Now, how do you prove that someone owns a duty towards another person? The case of Donagwe versus Stevenson has laid down what you call the neighbor principle. The question now becomes, who is your neighbor? The case said that you own a duty to your neighbor. Now the question now becomes, who is your neighbor? Lord Atkin, in the case of Donagwe versus Stevenson, pointed out that a person who is so closely and directly affected by your acts that you ought to have the person reasonably in contemplation when you are acting and directing your mind, that said person could be affected by your action. That person is your neighbor. So as a manufacturer, your neighbor becomes those consumers or the final consumers. So you have to do to ensure that the product you are putting it out there will not cause injury to any of them, because you have to know that if you fail to do proper package, or if you fail to put in the right ingredient, or you are careless and something that's unhealthy gets into the product, it is likely that the third party who is going to consume, or the final consumer, will suffer some injury. That's the neighborhood principle, or the neighbor principle. Now, the neighbor principle was also devolved, or another case came up to strengthen the neighborhood principle, or the neighbor principle. Now, that is the case of Caparo Industry PLC v. Dickman. He said, look, let's now adopt the principle of foreseeability, proximity, and fairness in deciding whether or not a person has a duty of care towards another person. Now, the foreseeability simply means that your action could cause, or you should foresee that your action could cause damage to the other person if you are careless. Now, the proximity is that the act should be sufficiently close so that it will be reasonable to cause damage to the other person. Now, after you have reached this conclusion, you have to also establish that whether or not it is fair to impose duty on the defendant. So for Caparo, you have to pass the test of foreseeability, proximity, and fairness. If the act was foreseeable, if it is proximate, but it is unfair, the court will not impose duty of care. It means that you don't have any duty of care. So before the court will impose duty of care on the defendant, then the court, relying on the case of Caparo Industry PLC v. Dickman, you have to satisfy the test of foreseeability, proximity, and fairness. Now let's look at liability for omission. When you omit to perform an act, what are the liabilities? The general rule is that there is no liability for an omission to act. However, this decision or general rule is subject to some exception. Exception number 1. The law says that where a defendant has control over the situation. So if you have control over the situation, then if you don't act, your omission will constitute negligence, or because of your omission, liabilities will be imposed on you. 2. The defendant has assumed responsibility. So you have assumed responsibility to take care of someone and you fail to do so. Then you'll be liable if that person caused injury to another person. Now, where a defendant has created or adopted a risk, so when you yourself create that risk or danger, then your omission to control that event, the court will face liability on you. Session summary. We have discussed broadly what constitutes negligence and duty of care. We have also identified occasion to which party will own a duty of care. We have also indicated that sometimes in contract there could be elements of duty of care being breached. We also said that the following must be present before an action for negligence can be successful. We indicated that there should be a duty of care owed to the other person, and that duty must have been breached, and because of the breach, the other party has suffered some loss. So because of the losses that was suffered by the other party, an action for negligence may suffice if the court satisfies that you have satisfied all the ingredients or all the elements for negligence. So let me take that portion again. You have a duty of care, and that duty of care, you have breached that duty of care, and because of the duty of care you breached, the other party has suffered some losses or damages, and therefore the court will come into the person's aid to award damages against you. Thank you and have a nice day.